Oh, no, I don't have any files. All right, and then Denny, I'll give you your reset. Just give me a moment.
Norma said that you wanted me to meet him if he's still here.
Oh, he should still be here. Mr. What is your client's name?
Hang
Mr. Pena? Hi, your attorney is here. I want you to get a chance to meet him. Just give us a moment, okay?
Thank you.
Yeah, just give me 2 seconds. Okay. Yes.
Thank you.
You're welcome. Okay, yes, just give me 2 minutes. Sorry. Who's with the interpreter?
I am, Your Honor.
All right, if you can come forward. And where's your client? All right, let me just take this up with the interpreter, then I will take your case, and then Mr. Cox, it will be you. I hope that everybody had a halfway decent lunch. All right, on David Leon, we have an interpreter. We're not on the record. Although he tried to teach me a little Spanish over the break. All right, so Mr. Cano, where are we on this case? Because there were some discovery issues.
Okay, all right. The last time we were here, my client was incarcerated. He has since been released on bond. He has been cooperative and in touch with me and is providing assistance. You also appointed an investigator since our last hearing to help me out. And she's still working on this, but here's what we found out. Because you asked me before whether I felt I had everything in discovery.
Mhm.
Well, we've come to learn that we believe that there's a material witness, a person named Nicholas without a last name who was not disclosed in the police report. We also have found out that there are two witnesses who, with their smartphones, took apparently some video, because this is what they admitted to the police on what was given to me about things that have happened before the police got there, which is what the case is all about.
So is this something that the state has, some video? Or is this?
Well, no, I don't, it's not in their possession, but what I'd like to do is subpoena one or two of these witnesses to court in our next setting and have the court order them to give me what they have on their phones having to do with this case.
You'll have to subpoena phone records or whatever for them. I can't.
No, I'm asking, I wanted to subpoena the people who have the smartphones with the video. We're talking people who took video of the incident that my client's charged with.
I mean, you can subpoena them, but I can't do anything with regards to forcing them to turn over phones or anything unless, there's a hearing on that.
Well, then that's what I need to do, is try to get a hearing on it, see what they have. I'd like to issue a subpoena, duces, take them, see what they have, and then decide from there whether there's anything, but I'm going about what they admitted.
So my understanding, this discovery issue is one stuff that you know about that the state doesn't know about.
Correct.
That part. Okay, and then what is the discovery that the state knows about, or you think the state knows about that you don't have?
That there may, I'm not even sure, I'm not saying that they know about it or withholding stuff. I'm saying that in the video that I looked at, there's several people there when the police get there. One of which is a person who my client claims to be visiting with. The allegations in this case are that my client tried to break into somebody's house. He says he showed up to visit some person who lived there. That person's in the video, but he's not identified in the police report.
Okay,
His name's Nicholas.
and so I don't when attorneys appear before me, I don't assume or make assumptions that anybody's hiding evidence.
Right.
I'm just trying to figure out what specific discovery
Yeah.
that maybe the state has that maybe they don't know they have, if they can get it for you. That's what I'm just looking
Okay,
at.
well, here's what specifically, there's a person named Nicholas, I'll leave his last name blank, who resided at the location. And we just need his name if they have it.
Okay.
Yeah.
All right.
If it's in our police report or in our possession, we can turn that over. If it's not, we can't turn it over.
All right. So this is what I'm going to do. I'm going to set this for 30 days.
Yeah.
And at that time, I'm going to expect an acknowledgement of discovery. And if somebody needs to subpoena a witness, because maybe they have something or you think they have something, you're more than welcome to do that and the court will hear it. Ms. Ferguson, can I have a 30-day reset on David Leon, please? All right, so we're going to come back on March 7th. Is your client a citizen?
No, he's not. That's another reason I was gonna ask you for a little bit more time, Judge, because he does have an immigration counsel who I need to confer with. The other matter that I wanted to bring up is I filed a motion for you to consider signing an order to allow him to work. He's got a monitor on, but he's not allowed to go anywhere, but he wants to be able to work.
All right, State, do you have any problem with him being allowed to work upon proof of employment and work schedule?
Not particularly, Your Honor, not familiar with the case, but it is early to have. And also he does have a pending misdemeanor family violence, so that's a concern with the states. But obviously, if I'd be at home with that person.
Okay.
You know, that's okay. That's a case from his baby mama, Judge. I think 3 or 4 kids.
All right, so this is the thing. With regard to his motion to work,
Mhm.
come back, and when you come back with where he's going to be working, and the court will let you know if it approve it or not.
All right.
All right, so Mr. Leon, we're going to be back on March 7th, and I've notated on the file that you already have an immigration attorney, so I will not be appointing an immigration attorney for you. And I've noted that on March 7th, if there are witnesses that need to be subpoenaed, you all will subpoena them.
Yes, ma'am.
All right, if there's nothing else, just get the reset form from Ms. Ferguson.
All right. Thank you.
All right, thank you.
Thank you very much.
Oh, Donata, I'm working on it. Yes, thank you so much. All right. All right, and do you have the document? Hello. So in this case, his client is in another state.
I spoke with him and we're okay with the motion.
Okay. There you go.
Thank you.
You're welcome. Cornelius, are you still working on something or you need me to look at something?
Just
Sure.
usually usually application.
Okay. And
Granted the license to deal with the technical error.
okay.
Because our secretary, when she printed it out, she said the license was suspended for 10 years, that is 2 years. So we just need to amend that.
All right. Thank you.
Thank you very much.
All right. Who is here on Janilius crew? All right. If parties can come forward. And I need everyone to whisper, please. Court is calling, and I'm sorry, there's only going to be a plea on one case.
Correct, Your Honor,
All right.
9281.
All right. Court is calling 2020 CR 9281 State of Texas versus Janilius crew. Can I have parties announced for the record for the state?
Jason Gearhand, Your Honor.
Defense?
Eduardo Jimenez.
All right. And are you Mr. Crew?
Yes, ma'am.
All right. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Crew, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor, however, the state is waiving the habitual status.
Any objection?
No objection.
Mr. Crew, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Kukuru, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
It's roughly, but I got accepted.
Well, no, I mean, are you satisfied with the way you've been represented?
No, ma'am, but I wish to go forward with the plea though.
All right. Do you wish to continue with this attorney?
No, ma'am. Well, far as, yes, yeah. I just
Oh,
wanna
so
get
you
it
wish
over
to
with.
go forward with this attorney
Yes, ma'am.
and you wish to go forward with this plea?
Yes, ma'am.
And have you had a chance to discuss this plea agreement in detail with your attorney?
Yes, ma'am.
And were you able to confer with your attorney and with the state?
Yes, ma'am.
All right. And do you wish to continue?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I do.
According to the plea, punishments be assessed at 20 years in the prison. There's an affirmative finding of deadly weapon. Court will take into consideration the following numbers, or the state will: 2020, 9280, 9282, 9279, 9278, 9277, 9276, 9275, 9288, 9287, 9286, 9285, 9284, 9283, and 9289. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
It's correct, Your Honor.
State is at the plea.
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, they have not.
And so the record is clear. Mr. Crew, my understanding, you wish to continue with this plea with the attorney who's present today. Is that correct?
Yes, ma'am.
All right, then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
The state offer seat exhibit number 1 without its patent, Your Honor.
Any objection?
No objection, Your Honor.
All right, Mr. Crew, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, we are, Your Honor.
Anything you wish to say on behalf of your client?
Not at this time, Your Honor.
All right, the court will follow your agreement, sentence you to 20 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Take in consideration the following cause numbers: 2020 CR 9280, 9282, 9279, 9278, 9277, 9276, 9275, 9288, 9287, 9286, 9285, 9284, 9283, 9289. Is there anything else from either side with regards to sentencing?
Other than the state, Your Honor.
No defense, Your Honor.
Mr. Crew, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you, Mr. Crew?
39, 50, 40, and February 25th.
All right, so you still have a lot of your life in front of you.
Yes, ma'am.
So you're gonna have to start making better choices. You're listed as a habitual. So, if you come back and you know how, this is Texas. So you're gonna have to do better. Is your mom still around?
Yes, she is.
All right, so you're gonna have to be a better son for your mom. She's gonna be dependent on you.
I was, when you put me on probation, I did everything I was supposed to,
Okay.
but. what you know,
Well, you know what my mom always would tell us and what my grandmother would tell us too? Nothing good happens after midnight. So we used to always try to be home at midnight. And when everybody's saying, oh, what are you doing for New Year's Eve? Our goal and our family is always for New Year's Eve is to make it to see the new year.
Right.
So all the celebration where people go out for New Year's Eve, I never did that. I would sit at home. Maybe I'd be with my mom or my family. And we would say, hey, we made it to see the next year.
Right.
But never out after midnight. Do you have any children?
Yes, I do.
What are their ages?
I have 4. 20, well, one could be 23, one could be 21, and I have 2 11-year-olds.
All right. And if the 2 11-year-olds, are those twins?
No, infidelities.
Well, at least you're owning it and claiming it.
Yeah.
But do better, right? We don't want this to be a Jay-Z or Beyonce where she ends up writing a song about you.
Right.
But then maybe so because she make millions for writing a song, right? But you take it easy and you have a good life. And I don't want to see you back here for this type of thing anymore. You understand?
Nah, I would definitely do better.
Okay. All right. Good luck to you. Okay.
All right. Thank you.
You're welcome.
Excuse Your Honor.
Yes.
Thank you.
You're welcome. All right. So who is next up for trial? Where's the? Where is Anthony Cantrell? What's happening with your guy? Yes. He's supposed to be entering a plea? All right. So what time on Friday?
11:30.
All right, Miss Ferguson, on Hawkins, have that come back on Monday. Uh-huh.
Can we, Monday's fine.
And this will be the last setting. Caroline, can I see the file on him? Oh, thank you. So we will be back on the 13th. Mr. Hawkins, we'll bring you back on the 13th. All right, and then the next person, Mr. Martinez, what's happening with your case? Okay, all right, just give me a second. There are a couple of people who are before you.
Okay.
All right, where's Daniel De La Garza?
He's completing paperwork right now.
All right, thank you. And then Philip Mosier. Okay. Okay, why do I have the file on Michael Montoya and Paul Donaldson and Ignacio Rios? Yes. Yes.
Those are scheduled for the end of this week and early next week. Notification letter. Excuse me.
So when is your vacation?
At least tomorrow afternoon, I'll be back Tuesday, so I'll be back in Fort Wayne. Mr. Montoya and Mr. Rios are set on, I think, a Wednesday.
Tuesday. They're set on the 14th and they're set on the 9th.
Okay.
Are these all criminal trial division cases?
Mr. Rios is a family clearance. Mr. Montoya and Mr. Donaldson are criminal trial.
All right, could I see someone from criminal trial division on this case? Just to give you an update. So Michael Montoya, that's a murder case that's set for February 10th, but he said he has a vacation letter in, so he's not going to be back till the following week. You say Wednesday?
Yes, sir.
All right, so on that one, he's pending a report from his expert.
I do have the report, so we should have at least some clarification whether a plea or trial.
Okay, and then his other case is Paul Donaldson, and that's manslaughter, and that's set on the 14th. I'm going to put all the cases together, but the only thing, that one is just scheduled for trial.
Okay.
And then, and I don't know if you all need the case numbers, because there's nothing left for you to do. And then state, I think it's Michael Villarreal or either Brittany. Ignacio Rios. This is one that's going to be reset because he has a vacation letter in.
Okay.
But it's for February 9th, the state was to check on some audio recording.
Ignacio Rios.
It's 22-10-366.
And 366.
So, Ms. Ferguson, do you want to put all of these on the 15th or the 16th?
March? You said February.
February.
Yes.
All right, so
15th or the 16th.
the 16th. Are you okay with the 16th?
Yes, sir.
People usually think they're going to come back from vacation on the 14th and then go right to work on the 15th. But they start thinking about the fact that I'm supposed to be retired and I'm not.
You gotta have a
So,
laugh. You gotta have
yeah. So I'm going to reset these all for the 16th.
All right, thank you, Judge. Thank you.
Okay. You need to let your clients know if they are on bond.
Yes, sir.
Looks like they've been concluded. Okay, let me.
All right. There's that. All right, the cases we have left on the docket is Philip Mosier.
Judge, I think that's gonna be a plea.
Okay,
Mr. Mauer has not picked up the paperwork yet.
all right, thank you. We have Matthew Gonzalez with Daniel De La Garza. Where is he? A plea, okay. And then we have Javier Medina with Bob Hicks. All right, so that's for trial, correct?
Yes.
Okay. And how much time do you all think you need for voir dire?
30 minutes, Rob?
Okay. And then we have Gerardo Yanez. Have we already done? We've done that one. Gerardo Yanez.
Yes, and I'd like to cut the marks, but
All right. And what about Rudy Gutierrez Gonzalez with Kelly Piddle? Oh, that was dismissed. And then we have Johnny Tejeda.
Sorry, Judge, what?
Johnny Tejeda.
We extended an offer that they've rejected. We'd like to put that offer on the record, if we could.
Okay, let me step out while you all put that offer on the record. And then I will come back. Oh, yes, he's on there. He's on coming up too. So,
I need to run down to County Book 12 on the trials.
okay, just let them know that you're up here. All right. All right, I'll step outside while you put that on the record. Are you all, excuse me, if he were to be found,
I'm sorry, guys.
if he were to be found guilty, would you all be coming to the court for punishment or the jury?
I think he's going to the jury.
We're going to jury. I thought we had filled out a punishment application a long time ago, but I definitely,
But
I'm
you
gonna
can say
check.
for the record.
all right, thank you, Judge.
is that what you said? I'm sorry. Okay. I thought you said.
All right, we're on the record in cause number 2022 CR 7806, as well as 7807 and 7808. South of State of Texas versus John Tejeda Jr. Present in the courtroom are the attorney for the state, Jason Jorgens, the attorney for the defense,
Alex Scharf,
as well as the defendants. The judge has stepped out of the courtroom so that we're able to put the plea bargain offer on the record. The state in the failure to stop and render aid causing death case has made an offer for a cap of 15 years TDCJ silence on the application for probation, or in the alternative for 10 years TDCJ with an opposition to the application for probation or deferred. This case is a second-degree felony in both counts, the failure to stop and render aid death, as well as the manslaughter charges. So if Mr. Tejeda is found guilty, he could be facing punishment anywhere from 2 years incarceration in the Texas Department of Criminal Justice up to 20 years incarceration. As a part of that agreement, the state would ask the court to take into consideration the remaining two causes. And it's our understanding that Mr. Tejeda is declining that offer at this time. If we could just get a verbal acknowledgement. Yes, correct. Okay. Then that's it. I think we can close the record. Thank you. Thank you.
All right.
All right, everyone, please be seated. right, so we are just waiting, and I'll take the pleas up before we have the jury come in. Yes.
I'm here for Charles Garley, Your Honor. Were we meant to be here this afternoon as well?
Oh, yes. Yes, so we'll see what happens.
Oh,
There's one issue that the defense wanted to raise.
so two issues, Your Honor. One, I guess after reviewing further the documents that were turned over from IA, that the court did an in-camera review for, I discovered that there's a potential that there may be more documents related to this offense. Either my belief or assumption would be that those were not provided to the court for review, because just a basic review of it, it makes me believe that there's more to it, and here's why.
Well, what I can tell you, everything that was turned over to the court, I reviewed it in total,
I understand.
and I gave you what I felt you were entitled to have.
That I understand. Well, what I'm saying is it's possible because of why the court's review of it, that perhaps what was provided to the court was an incomplete record, or there was something left out, maybe on another case number for this officer, because the IA case numbers under these documents that were provided to the court were for 2021-0048 and 2021-0049. And it looks like these records were reviewed by the department sometime in the following days immediately after the offense of January 23rd, 2021. And the dates that they have of when they reviewed it, some were something like January 25th and January 27th of 2021. However, my client received a letter from SAPD on October 22nd, 2022, that indicated that the chief of police at SAPD had reviewed his case further and indicated that there was, directly from the letter runner, chief of police has reviewed the incident and subsequently ruled that corrective action be taken against Officer Gabriel Artelejo, badge number 0113. So that was in October of 2022, outside of the date frame that we have here. Oh, you want me to provide that to Your Honor? I'm
Thank
sorry.
you.
It's a bad copy, so apologies. I tried to make it as clear as I could.
Okay, and let me see the other thing that I
Yes.
gave you.
But if I can step in real briefly, and you'll notice, Judge, that the case number that's on that letter, the IA case number, is different than the case numbers that were on the reports that were provided to the court.
Okay. All right, just give me one moment. No. Open the back office room.
I'm gonna go step out just now.
All right, so,
The state's attorney stepped out rather.
all right, Mr. Garhan he can take it out. So, of course, this is what I was given. And I reviewed, I did an in-camera inspection. And state he is correct. The case numbers are different. And so it appears that he hasn't received, or I haven't received the information from that 21 case. I only have the 2022. And so I think Mr. Cobb, I don't know if Mr. Cobb was aware of that, but I only have from this cause number.
Okay, I mean, I want to make sure that it's obviously two different cases.
Sure.
And I can reach out to Mr. Palm on that.
Okay, and I'm looking at the discs that I have,
Mhm.
and the discs are only IA number 2022. I don't have a 2021. So I'll give you a reset so that we can figure out what's happening with this.
Yes, Your Honor.
All right,
appreciate
and state how much time? Because I know, and what I will tell you is the date I will give you will be the date for me to see if y'all actually have that other cause number.
Yes,
And
ma'am.
then it'll be time for me to review that.
Yes,
So
ma'am.
you won't be going to trial on this date. This is for me to make sure you have discovery if you're entitled to it.
Yes, Your Honor.
But Judge, I mean, probably just a couple weeks at max. I mean, I should be able to get a response rather quickly.
All right, Ms. Ferguson, on Gurley, can I have a 3-week reset? All right.
Yeah, that one. This one, right? That's the problem.
I guess, I mean, whatever was associated with it, but
Yeah, this is. Okay, but I just want to make sure. I didn't know.
And if you all want to make a copy of that
Is this-
cover
is
page,
this the court?
yeah, the yellow one is the courts. So if y'all want to make a copy of it,
If
you
don't mind.
can. Yeah, that's fine.
I'm gonna go and go. My phone.
You said March 2nd or,
We'll get a copy.
all right, you can come back on March 2nd or either February 28th.
Either one of those should be okay. Well, actually, before I say, it, let me make sure. Let me call it. Either day works for me, Your Honor, so
All right, we'll do March 2nd just to make sure that everybody has everything.
appreciate it.
All
Thank
right,
you, Judge.
you're welcome. Just get a reset form from Miss Ferguson.
Well.
All right.
And Judge,
Yes,
he's making a copy and we'll bring that back for that file.
all right, thank you.
Judge, are we still on call?
Yeah, just give us a second. We're doing some pleas right now. Oh, Deputy Laura. These are extra. I don't know what they are, but they're supposedly lightweight. All right. You write down that one? Oh, I'm sorry, that's a reset. Okay.
Yeah, I'm about.
And then we also have this. I say we have them. It's better to have it and not need it than to need it and not have it. All right, who's here on Philip Moser?
That would be me, Judge. Mosier, not Mosier.
All right. All right, if you'll come forward, please. Yes, you're there.
I'm gonna bring my own signs. I'm gonna put them up this, so I'll remember. Because every court I go into, it's different and I never remember where I'm supposed to go.
All right, court is calling 2021 CR 7283, State of Texas versus Philip Nelson Moser. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense.
Robert Mauer for defendant, Your Honor.
And are you Mr. Moser?
Certainly.
All right. Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Moser, showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Moser, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That is a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Moser, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's $1,000 fine. State recommends deferred adjudication. There's to be restitution, if any, to Noe, N-O-E, Lopez, and there's an affirmative finding of deadly weapon. Did you understand that to be the plea?
Yes.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Noe Lopez and Maria Pena, no firearm possession, and regular UAs. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
State officer, state exhibit number 1 with all the attachments, Your Honor.
No objections.
Mr. Moser, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, I would like to proceed with sentencing with PSI.
All right, anything you wish to say on behalf of your client?
Judge, yes, my client, since this case was filed, has taken some anger management classes. And I think addressed those issues. I'd ask the court to grant his application for deferred. I would note he's been having problems with employment since this case has been pending. I'd ask the court to probate as much of the community service hours as the court felt possible so we can try to get back to being gainfully employed. And I think the restitution was covered by his auto insurance. So I'd ask the court if there are any issues moving forward, if we can just reserve the right to have a hearing on the restitution issue if there's a question about that.
All right, are you still at these apartments?
Certainly not. No, ma'am. I'm not. No, Your Honor.
Okay.
I am in the west side.
Okay, do you have any children?
No, Your Honor. I have a cat.
You have a cat? What's your cat's name?
Arjuna.
Arjuna.
Arjun.
Arjun.
That's
Middle name?
That's name. No middle name.
Last name?
I think he was one of the Pandavas. He was his namesake.
Oh, okay. All right, I always just have questions. Do you let your cat at night to roam?
Yes.
All right, so help me understand this. People who have dogs, they walk their dogs and they clean up after their dogs. People who have cats seem to think it's okay to let their cats to leave the house at night, to go to neighbors' homes who don't have cats, to do their business, and just because they cover it, somehow people think that's okay.
Maybe Judge, if there's a personal issue, you should get a net and you can net the cat
No,
and hold it hostage.
I'm just always wondering why this is the case.
They're just instinctively more independent, cats are, so they don't need a human to follow them around like that.
Well, but I've seen people walk their cats on leashes. I'm just saying. I've seen this.
I would definitely do that. I'm that little guy.
Okay, all right. I'm just wondering. So how have you been supporting yourself? Your attorney told me you're not employed.
I have had 4 jobs in the last 2 years, when Taco Bell, Toyota, point of sale, configuration services, which is the closest I've gotten to my career field. And then finally, I just got done with a seasonal contract with Walgreens.
Okay.
So I'm looking at another few contracts with, I'm hoping for a managed service provider like Spectrum or AT&T.
Okay. And are there any drug issues with you?
No, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's $1,000 fine that will be probated. Restitution, if any, to Noe Lopez and counsel. If there's an issue with the restitution, we can always have a hearing on that.
Yes, ma'am.
There's an affirmative finding of a deadly weapon. 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get that, but if you do, 40 of those hours will be waived. If you obtain some sort of certification in your field, the court will consider waiving the remaining of the hours. So that's up to you. I'm all for people improving themselves. So there is to be regular reporting by Zoom or in person. There's to be regular UAs. Probation, we'll do 1 field visit per month for 2 months. If there's no issue with the field visits, then you can discontinue them.
I'll be there.
Proof of employment within 40 days. There's to be no employment as a home health care provider or with minors. And no firearm possession.
Sure.
And no contact with Noe Lopez and Maria Pena. Probation, is there anything else he needs?
No, Your Honor.
Defensive driving? I'm just throwing it out there. It's based upon what I've read. All right, is there anything else you need from the court to be successful?
Certainly not. I really appreciate the certification that element. That's very helpful. Because I do have funding for that. And I will get, I have intention to renew my my security plus. as soon as possible. So thank you very much.
All right, you're welcome. And thank you for always dressing appropriately for court. I don't know if Mr. Maurer had anything to do with that or not, but I'll give him credit for that.
Fashion is my hallmark. Judge.
All right, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So, Mr. Moser, I believe in this courtroom, communication is always key. And when I place people on probation, I'm expecting them to be successful at it. So make sure you stay in contact with your probation officer. And from here on out, everything that you do, you need to ask yourself before making that decision, is this something that could potentially result in me going to prison for 20 years? Okay.
Yes, Your Honor.
All right. Good luck.
Thank you, Judge. May I be excused?
Yes. And Robert, you had better get that taken care of.
I'm waiting for the doctor to call me back. Now I have to go in tomorrow.
Okay. So, you know, my mom always says, don't wait for the doctor to call you back. You got to.
Rachel's like, drive to Bernie.
Oh, okay. Now Rachel's, yes. Tell Rachel if you're driving early in the morning, yes.
Too much work in the middle.
Yeah. All right. The court is calling 2022 CR 10839, State of Texas versus Matthew Gonzalez.
Your Honor.
Oh, off the record, Bashan, you still need to talk to Mr. Moser, right?
Yes.
Okay, sure. All right, we're on the record. Can I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Daniel De La Garza for the defense.
And are you Matthew Gonzalez?
I am, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
I did, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 1 and we'll waive the remaining counts.
No objection, Your Honor.
All right, Mr. Gonzalez, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Your Honor.
Did you understand your charge in count 1 with sexual assault of a child? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
I'm sorry, what was that?
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
No, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
You believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. The state will remain silent on your application. There's to be Chapter 62 requirements and no contact with the complainants. Did you understand that to be the plea?
Yes, ma'am.
Defense?
I did, Your Honor.
State?
Yes.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
I did, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense is charged in count one. How do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
The law proceeds exhibit number one and all attachments.
No objection.
All right, I'm showing you what's entitled waiving and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments and review the same. All right, we're going to go off the record for a moment. If counsels could approach. Daniel Escobar is zooming in. Is there a reason he's zooming in?
Yes, there was a, someone who wanted to give a victim impact statement. I was trying to join just to speak with them in the breakout room.
Okay, sure. All right.
Have they joined already?
No, they.
Okay.
All right. And but Sean, I did do the ignore. So right click and ignore. That works. Because everybody just kept responding and they kept responding. Like, why am I in this chain? Why even respond? Just delete it.
That's what I said.
No.
That's exactly what I said. It doesn't pertain to you, don't respond to it.
Yes.
Just delete it.
And let me just tell you, last night, I was getting messages at like 2 a.m. and this county phone kept binging. And so finally, I was just like, you know what? I'm going to get up. I'm going to Google how to put this thing on Do Not Disturb.
Judge,
I do. All right, I'm depending on you to do that. Because, and some of it, I thought maybe it was hooked to this email. So I'll delete emails from the computer and it still shows up on the phone. You know, everything is in the cloud. We shall see. Tonight, Poker Face comes on.
oh, really? Does it end up just binge watch?
I'm hoping it never, well, all good things must come to an end, but I'm hoping it does at least 2 seasons. But I think so far it's maybe 5 episodes, but it's very good. All right, so state and defense, it wasn't my imagination.
I don't,
It's Mr.
I'm not confident that they're even this. She's referred to as Jane Doe, but I don't see a pseudonym form. So I may have to amend.
Okay.
Maybe just.
Oh, it's found it. Michael found it.
Ah,
But
okay.
Oh, okay. Yeah, just give me a second.
Okay,
All right, sure.
and lead off for state exhibit number 2.
Okay. LaShawn, I've always loved to read. You know, my brothers, when they were in school, they would say, Stephanie, read this book and tell us what happened. And my mom would say, she's not reading your book. I think I probably was the only child in elementary school who had read War and Peace and Tale of Two Cities. I was like, this was interesting. But I think I finally checked out when one of my brothers wanted me to read Far Horizons. I'm like, this book is horrible. But no, you know, I'm sorry for the people who love Far Horizons, but that was one boring book. And everyone else, thank you for waiting patiently.
Because we have a plea in Mr. Teja's case after.
Oh, okay.
We're ready.
Okay. And we're going to go back on the record in 2022 CR 10839.
The state office states exhibit number 2.
All right, and so states exhibit number 2, in addition to states exhibits 1 and attachments, is that correct?
Yes.
All right, defense, do you have any objection?
No, Your Honor.
All right. Then, as previously stated, the court is finding that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And just so the record is clear, Mr. Gonzalez, did you see the pseudonym form that the state is adding to their their evidence?
Yes, ma'am.
Okay. All right, after reviewing States Exhibits 1 and attachments and States Exhibit 2, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. We are going to come back on April 3rd. Is there a need for any type of TAP evaluation, counsel?
No, Your Honor, you have no drug or alcohol problems. I just tell the judge.
I do not have that whatsoever.
All right, so we're going to do a PSI. I'm going to make a decision on your application based upon the PSI report I received and any other evidence that's presented. So you'll be back here on April 3rd. Ms. Ferguson will give you a reset form and we'll be here at 9 a.m. All right, thank you.
Thank you.
Thank you.
Thank you all very much.
Yeah.
I was told that the witness was Andrews on the Zoom call. Has she joined yet?
No, she has not. Do you have the, I'm assuming you have the correct zone identification?
That's what I'm going to double check it.
Okay. All right, so we have Mr. Medina's left and they're doing some different paperwork, so just give us a moment. And then Mr. Amir Memori, your client is, what is his name? All right, Marcelino Scott. Okay, just give us a moment. We're completing these, please. But what I can tell everybody, it appears that we're gonna do, we may end up doing jury selection tomorrow morning. And since Wednesday, we don't have a docket, we'll do jury selection and go straight into any testimony.
Judge,
Who's gonna go, Judge? Yeah.
I don't know. I'm trying to see which pleas are working out.
I just had I thought that I thought two murders were set tomorrow.
Okay. Okay.
Oh, okay, well,
Oh, no, we'll do that in the morning.
okay.
And then
I just wanted
this
to make sure.
shouldn't take more than probably like maybe 10 or 10:30 we'll start with the trial.
Okay, Judge.
All right, thanks.
Thank you.
Thanks for bringing that to my attention.
It was brought to my attention. So
Yeah.
I can't take credit for that.
All right, so Deputy Laura, do you want to let the jurors know to come back? We'll send Mahia out. All right, yes. If you can tell them to be back here tomorrow at 10. Yes.
Let us know if there's any juror forums out there. From last time. You remember him? Yeah. Mr.
All right, can you meet us? So of course, you know what I'll be busy doing today. I have to upload the exam for my class. So that's what I'll be doing. Yes, who is your client?
Fabulous.
Fabulous. Okay, let me find him on the docket. All right, so Norma, my understanding is that we have one Pablo Aviles. And we have Javier Medina. And Marcelino Scott. Is that the only 3 cases we have left? Oh, you know what? It's easy just to ask Caroline because she has the files. So just those 3, correct? All right. So on Javier Medina, Juan Pablo Aviles, and Scott Marcelino, we're going to have you all come back tomorrow for trial. So if you all can be, I told the jury panel to be back here at 10. If you all can be back at 9:45.
Just, I've got to go to, I've got an 8:30 setting in federal court. I'll be here Susan Delta.
Okay, no problem. And I'll put a notation that you're in federal court.
Okay, thank you, Judge.
All right, thank you. And where is your client?
He's on the home.
Just get a reset form from Miss Ferguson. All right. And then this will give your client a chance to get pants.
Yes,
Okay.
I do have a motion.
Hmm?
I do have a motion in lieu. I would like to have.
Okay. All right, if you want to, we can do it in the morning. What's your motion in limine?
It's basically fairly simple. It's the pretty much standard stuff. Nothing that violates 404B.
Okay. All right, so I will tell you on the motion in limine because I really don't know anything about the case until evidence is being presented. I always ask the state to just approach them before they get into it.
Okay. Well,
But
that's
I will tell you, I don't expect them to get into any 404B without approaching anyway.
Well, I don't think there is any.
Okay.
The motion is a motion. The only thing that's relevantly specific is not eliciting testimony regarding any statements made by the defendant before.
Okay.
There's a hearing on whether it's admissible under.
Okay.
That's, I think, paragraph number 4, maybe.
All right. Can I see Mr. Medina, if you can come forward? All right. And I understand about the short situation.
Yeah.
All right. So you're requesting the jury trial, correct? Oh, you have to answer so I can hear.
Yes, ma'am.
All right. So what we'll do is we'll be back here tomorrow. State, how long do you expect this trial to last? Okay. And so then state, just make sure you have your witnesses here tomorrow.
Yes.
And defense, do you anticipate, and I'm not holding this to you, but do you anticipate calling any witnesses? If you are you able to have them here tomorrow?
Yes.
Okay. So is there something, I don't know about this case, it's a possession less than a gram case. Is there some issue that I don't know about or something that I need to know about? Is this something that is bench trial worthy, not bench trial worthy? You just let me know.
Now, or
I mean, if you wanted to discuss it with the state, of course, Mr. Medina, if you request a bench trial, the state has agreed to a bench trial because they're entitled to a jury trial as well. So I don't know if you all want to talk about that, but I see that his election of punishment is to the court. So, I mean, it's completely up to you all. And what I think, I'm pretty sure that everybody knows, and I'm sure every other judge is like this as well. If someone comes before me for a bench trial, for me, whatever the charges may be, the evidence is what the evidence is, and I may base my decision on the evidence that's presented to me.
I would hope so.
Yes, okay. So I don't know if you guys want to speak about that or not.
Maybe we should.
Sure.
this takes a moment to come.
All right, State, would you like to speak to me? All right, just have a seat, Mr. Medina, and we'll be with you.
Our cases have like 8 hours worth of video. We've got
Johnny Tejeda?
Judge, before, Lee, just to let you know, we do have a victim impact statement and the next of kin was not able to log into Zoom, so we'd be asking for a reset for sentencing in this case.
Sure. And we can, if they want to appear by Zoom on a different date, we can do that on a different date. So just let me know when they'll be able to Zoom in. Does anybody have an idea?
I don't know, we had tried to meet with her yesterday as well by Zoom and she wasn't able to do that, so it may be easier to bring her in person for it.
All right, do you have an idea of what date you want to come back on? If y'all can check on that while we do the plea and then we'll see. All right. Court is calling 2022 CR 7806 State of Texas versus Johnny Tejeda. Can I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense.
Alex Shar for Mr. Tejeda.
And are you Mr. Tejeda?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tejeda, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving count 2 and proceeding on count 1.
Any
No
objection?
No objection.
Mr. Tejeda, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 1, you're charged with the offense of failure to stop and render aid resulting in death? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today? I'm sorry. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
And did you understand in regards to your plea bargain agreement, the court does not have to follow that agreement?
Yes, Your Honor.
And if I don't follow that agreement and give you more than you bargained for, you can withdraw your plea. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe that. Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both.
Mr. Tejeda, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 1, waiving count 2. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. No application for deferred adjudication. State recommends community supervision. They will take in consideration 2022 CR 7807, 2022 CR 7808. There's to be restitution payable to the next akin for Dylan Trevino, Melissa Aroja, ARAUJA, and then payable to victims under 2020 CR 7807, Mario Huarte, YTUARTE, and 2022 CR 7808, Monica Bell. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, Your Honor.
Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
We haven't had any hearings on any motions.
Next, I'm showing you outside the plea bargaining agreement. State is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 200 hours of community service restitution, the MRT and regular UAs. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged in count 1. How do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yes, Your Honor. The state offers exhibit 1, the defendant's waivers and stipulation of evidence, as well as the discovered knowledge for this case.
Any
No
objection?
objection.
Mr. Tejeda, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statement and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. And state, have you had an opportunity to receive a date?
Your Honor, our next of kin indicated that she could come in on any day, so sometime later this week should be fine, or at the court's convenience.
Okay, does she want to come in tomorrow or Thursday or Friday?
Just give her some time. If we could do Thursday or Friday, Judge, just to make sure she can. Oh, or not.
I can't do Friday.
Oh,
I have a
okay.
federal sentencing in Del Rio in the morning.
So then Thursday, Judge, if the court's okay.
Is Thursday okay with you?
I'll have to check my schedule, but I think it is. I will do that before I leave,
Okay. Oh, well, you want to check it now?
just to be sure.
Oh, yeah, sure. Go ahead and check it.
All right.
And thank you, Judge. We appreciate the court's
Oh.
accommodation for this.
Oh, no problem. And Caroline, before you go, could I see the file on Mr. Scott, or have you already taken that back? Thank you.
Set in Kendall for an arraignment in the morning. we may be able to waive that arraignment. I could be available in the afternoon.
All right, how far is Kendall from here?
It's not too far from me because I live out that way. It's about, but getting out of that court is, half a morning type thing.
Okay, do you want to set it for Thursday in the afternoon?
That would be great.
All right, State, are you okay with Thursday? And let's say Thursday at 1:30?
As far as I know, Judge.
All right, so Norma. On Mr. Tejeda, we'll come back for sentencing on the 9th at 1:30. All right, is there anything else from either side?
No, Your Honor.
All right, if you'll get the reset form from Ms. Ferguson, then you're excused.
Thank you.
You're welcome. All right, so you wanted to approach on Mr. Scott?
Yes, Your Honor.
Mr. Scott, you want to come forward? What's the issue?
Judge, in this case, I've talked to Mr. Scott about the case. And my sense, Judge, is that Mr. Scott does not have the confidence in the assistant attorney. And I've talked to him, and he's in agreement that he'd like to approach the court and ask for another appointment.
All right, Mr. Scott, you can always hire an attorney. What I can tell you is this is the way the appointment list works. Anybody who's on the list to receive appointments must have certain requirements, so they're put in on that list to receive appointments. And your attorney is on the list to receive appointments at this level of felony because he meets the requirements for that. Now, I'm going to tell you what I've told a lot of people. Sometimes the problem is maybe you don't want to hear what people have to say, right? But police reports say what police reports say, and then whatever other witnesses or information that anybody has, they say what they say. You understand? All right, is there anything else?
No, Judge, I'm going to review your rate. I'm going to ask the court to please see if you're willing to appoint another attorney.
All right, I'll see you guys back here tomorrow at 9.
9 o'clock?
Yes,
Thank you.
you're welcome. All right, is there anyone else left on the docket? All right, so we'll be back here tomorrow at 9 a.m. And maybe by then, Bashan will have seen that episode of Sanford and Son about I want my daddy's records. I can't believe she hasn't heard of that. Oh, well.
It was one of the first when I looked up Sanford and Son on YouTube. It was one of the first.
It is. It's the first one. That, Deputy Laura, that's akin to not knowing about ruby slippers.